In the aftermath of Judge Torres' ruling in the long-running Ripple versus SEC case, legal experts are predicting that both Ripple and the U.S. Securities and Exchange Commission, SEC, may file appeals in the coming months. While some reports suggest that the SEC may not challenge the court's recent decision, lawyers argue that appeals on earlier rulings, including the summary judgment, are still a strong possibility. The Southern District of New York recently concluded the case by ordering Ripple Labs to pay a $125 million penalty, significantly lower than the $2 billion initially sought by the SEC. While this reduction in the fine is being hailed as a victory by Ripple, the court also granted the SEC's request for an injunction. This injunction permanently prevents Ripple from selling XRP to institutional investors and through its on-demand liquidity, ODL, service without a proper registration statement. Ripple's CEO Brad Garlinghouse and Chief Legal Officer Stuart Aldarity expressed satisfaction with the verdict, emphasizing that the reduced penalty reflects the court's acknowledgement of the SEC's overreach. Garlinghouse noted, "The SEC asked for $2 billion, and the court reduced their demand by 94%, recognizing that they had overplayed their hand. We respect the court's decision and have clarity to continue growing our company." Despite some speculation that the SEC might forego an appeal, legal experts believe that an appeal is still on the table. Bill Morgan, a lawyer supportive of XRP, pointed out that neither Garlinghouse nor Aldarity made any definitive statements regarding the SEC's next steps. Former SEC lawyer Mark Fagel added that the agency has 60 days to file an appeal following the ruling and can still do so after Ripple pays the civil penalties within 30 days. Fagel suggested that if the SEC does file an appeal, the penalty payment might be held in escrow until the appeal is resolved. Attorney Fred Rispoli added that Ripple Labs would likely only file a cross-appeal if the SEC initiates an appeal first. Notably, the SEC has not used the term appeal in its communications, nor has it strongly contested the court's decision. Ripple, on the other hand, maintains that its current XRP sales do not qualify as securities under existing regulations. Attorney Jeremy Hogan offered further insight, stating that Ripple's ODL sales are likely to continue despite the injunction. He explained that most of Ripple's ODL sales occur outside of U.S. jurisdiction, meaning they are not subject to the court's ruling. Additionally, XRP sales to institutional investors can proceed as long as they comply with one of the 5 exemptions to registration requirements. Ripple has also adjusted its sales practices to align with the summary judgment. Judge Torres did not provide the SEC with the broad language it sought regarding ODL, thereby requiring the agency to present specific evidence of violations. Hogan also noted that Ripple could argue that there is no expectation of profit when XRP is held for only a brief moment, further complicating the SEC's case. Following the court's ruling, XRP's price surged by over 30%, reaching around 60 cents. However, despite this initial spike, trading volume has dropped by 56% in the last 24 hours, and the price has shown signs of weakness. Analysis from CoinGape suggests that whales have started selling off their holdings, contributing to the current downward pressure on XRP. In conclusion, while Ripple celebrates a significant legal victory, the possibility of appeals from both sides looms large, and the market remains cautious as the situation continues to develop. So, that's the update for now. Thank you for watching, and see you in the next video.